We have some rules of fair play for the lawyers who conduct trials. That is, fairness to the opposing party and opposing counsel. These come under Model Rule 3.4, which the American Bar Association calls fairness to opposing parties and counsels. These are separate from the rules about truthfulness toward the court itself or to the judge. Rule 3.4a begins with a prohibition about hiding and destroying evidence. It says that a lawyer shall not, 1, unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. This means that you should not destroy potential evidence, like with a paper shredder. This should be obvious, but you could be subject to discipline for doing this, even if your client insists on it, and even if it is the only way to help your client win. Rule 3.4a continues, a lawyer shall not counsel or assist another person to do any such act, in other words, hide or destroy evidence. So it would count as a violation even if you have a secretary or a legal intern destroy evidence for you, or if you direct the client themselves to do it. Rule 3.4b says that a lawyer shall not falsify evidence, or counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. If you think about it, this is sort of a mirror image of destroying or hiding evidence. You're fabricating evidence. This could be something like a deepfake video, or a fake voice recording, or a photoshopped image, or forged documents. You also can't bribe someone to testify in your client's favor or threaten them not to testify for the other side. I'll come back to the situation about witnesses after we finish the remaining sections of this rule. Rule 3.4c says that a lawyer shall not knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. In other words, you cannot simply ignore, say, discovery and production requests that you do not like. If you think you don't have to disclose something the other side asked for, say, because you think it's covered by privilege, you have to declare your objection openly. You can't just pretend you didn't hear it or see the request. In other words, if you're disciplined for hiding evidence, it won't be a defense that the evidence was protected by attorney-client privilege or something like that, unless you asserted that as part of your refusal to turn it over. Also keep in mind, we've said this before, that in general you won't be subject to discipline for violating most of the rules if you are doing the activity pursuant to a court order. So if a judge orders you to do something, you're not going to be disciplined for doing what the court order says. Let's move on. Rule 3.4d says, a lawyer shall not, in pretrial procedure, make a frivolous discovery request or fail to make reasonably diligent efforts to comply with a legally proper discovery request by an opposing party. So besides the court sanctions that you might encounter for refusing to comply with proper discovery, you may have learned about that in your civil procedure course, a lawyer could be subject to discipline with the bar for discovery abuses, either for making frivolous discovery requests or refusing to cooperate with discovery. When I was in practice, I've seen both. Of course, someone would have to file a complaint with the bar. Otherwise, they would have no way of knowing that you did this, and honestly, a lot of times people don't do that. Let's move on to Section E. Rule 3.4e says a lawyer should not, in trial, allude to any matter that the lawyer does not reasonably believe is relevant, or that will not be supported by admissible evidence, or assert a personal knowledge of facts and issue except when testifying as a witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. Now, that's a lot to take in, but before we move on from here, note this may contradict what you've seen portrayed in movies and TV shows about the courtroom antics of lawyers. A lawyer should not try to vouch for the client's character and say something like, "I've known this client for years, he would never lie," or express an opinion about witnesses lying, or tell the jury that you have your own personal experience with such and such if it's an issue in the case. If you're going to say that, let's swear you in, put you on the witness stand, and have you testify. Now, this concludes our first lecture about Rule 3.4, and I've covered sections A through E. In the next video, I'm going to cover the remaining section, F, which is about paying witnesses who testify at trial.